The order of the High Court has been stayed, and the next date of hearing is 7th of February. There were 2-3 very important observations which has been passed by the Supreme Court. The opening comments of the Supreme Court was that this is a human issue. Human rights are involved. You cannot tell people who have been living here for 60-70 years to get away from their houses within 7 days. It cannot be done. Second, Supreme Court said you should prepare a scheme for rehabilitation of these people. Even if you say that vacate this land, you should prepare a scheme for rehabilitation. Thirdly, Supreme Court said that the comments of the High Court, the comments in the judgment of the High Court saying that paramilitary forces and the police forces should be used for vacation of this land is completely uncalled for. These are your citizens. You cannot tell them to vacate this within 7 weeks. Otherwise, paramilitary forces will forcefully vacate that land. So these are the things which has happened, and they have told the Northern Railway, the railway and the state government to prepare a rehabilitation scheme so that a balance may be struck between development and rehabilitation and protection of rights of the citizens.
So the Supreme Court has also given suggestion to the railway and other government organizations that there should be some outcome, that there should be mutual understanding between this kind of evacuation cannot be done over a night. So in such observation, what is your view on this observation on Supreme Court suggestion that?
That is what Supreme Court said. You cannot overnight throw people who are living in their houses for 50, 60, 70 years and they claim they have registries, they have done mutations of their land. You cannot do that. So this is a human rights issue. This is uncalled for to issue notices to vacate within 7 days. The problem is that the impugned judgment of Nainital High Court said that you can issue notice post the judgment on 20th of December 2022 and give them 1 week time for vacation of the land. So the judgment itself is wrong. The judgment of the Nainital High Court, in a way, is against the human rights of the citizens of that place, residents of that place.
I will try to understand from you, sir, since there is a huge controversy, huge confusion is there. Railway claims that the land belongs to them. The people claims that the land belongs to them. So what is the crux of your petition and what is the crux of this controversy?
You know, it's a long legal issue, but in short I can tell you, it started in 1907 when Nazul rules were applied to that place. And people started, the revenue record started to maintain. In 1939, when UP Tenancy Act came into force, UP Tenancy Act was enforceable on this place as well, because this place was also part of Uttar Pradesh, undivided Uttar Pradesh, which later became a part of Uttarakhand, this land. And subsequently, state government auctioned this land, and these people most of them became auction purchasers of this land. Mutation of that land was done. Subsequently, in 1994, in a dispute in relation to one of the resident of that place, railway filed an affidavit saying that we have 45 feet of land on the eastern side from the railway track and 70 feet of land on the western side of the railway track, which total to some 29 acres. Now the railway is saying that they have some 80 acres of land. So railway itself doesn't know how much land that own. The state government said that this is their land. Railway said that this is their land. ASG has now said that they have prepared a report for demarcation. Nobody knows what is happening. We say that it is our land.
नमस्कार, मैं हूं मानक गुप्ता। अगर आपको हमारा ये वीडियो पसंद आया हो तो इसे लाइक और शेयर जरूर करें और हां, हमें सब्सक्राइब और फॉलो करना ना भूलें ताकि आप देश और दुनिया की कोई खबर मिस ना करें। तो जुड़े रहिए हमारे साथ और देखते रहिए न्यूज़ 24।